The Third Circuit Court of Appeals has just made a surprising move in one of the most important Second Amendment battles we've seen recently. As many of you know, the Supreme Court recently declined to take up several high-profile cases involving both rifle bans and magazine bans. However, the court made it clear that they are watching these cases very closely and may consider reviewing one or more of them in the near future. They essentially signaled that, when the right case reaches them on the merits, they could be ready to step in. Well, one of those very cases is now in a critical stage. The Third Circuit has stepped in and taken it for en banc review. What makes this so unusual is that the case was already being handled by a 3-judge panel at the appellate level. That panel had already heard oral arguments and was expected to issue a ruling. But before they could, the full Third Circuit intervened and pulled the case from the smaller panel. This means the case will now be reviewed and decided by the entire en banc panel of judges instead of just 3. This development is significant. On the one hand, it accelerates the process because the case skips a step. It won't be waiting on a panel decision before moving forward. On the other hand, it raises the stakes dramatically, because whatever the en banc panel decides will carry even more weight and could set the stage for a direct challenge at the Supreme Court level. Remember, the Supreme Court has already said they are paying attention to how these types of cases are resolved in the lower courts. There's also reason for cautious optimism here. The Third Circuit has, in recent history, issued decisions that strongly protect Second Amendment rights. For example, in the well-known case of Range v. Garland, the court sitting en banc ruled in favor of gun rights under the standard established in Bruen. That track record gives hope that this new case, challenging both New Jersey's so-called assault weapon ban and its ban on standard capacity magazines, might also result in a favorable outcome. To put this in perspective, this case could be one of the most important challenges to gun bans since Bruen. If the Third Circuit rules against New Jersey's restrictions, it not only strikes down those laws but also sets a powerful precedent that could ripple across the country. And if the decision eventually makes its way to the Supreme Court, it could be the case that finally forces the court to weigh in directly on so-called assault weapon and magazine bans. After the Supreme Court's guidance in Bruen, the district court was required to reassess the state's restrictions. However, instead of carefully applying the clear framework the Supreme Court laid out, the district court issued what can only be described as a deeply flawed ruling. The judge openly expressed reluctance to accept the Supreme Court's directive that certain firearm policy choices are simply off the table. In his written decision, he even noted that it was difficult to embrace the court's pronouncements, especially considering, in his words, that radical individuals often misuse these firearms for evil purposes. Yet despite admitting that he was bound to follow Bruen, the judge crafted what looked like a patchwork or hodgepodge analysis. He selectively protected only a narrow category of rifles, while at the same time upholding the state's sweeping ban on standard capacity magazines and ignoring many other commonly owned firearms. In effect, the court tried to minimize the impact of Bruen rather than apply it faithfully. This flawed decision did not stand unchallenged. It was promptly appealed and has since moved up to the Third Circuit Court of Appeals. On July 1st, the case was argued before a 3-judge panel in the Third Circuit. During oral arguments, both sides presented strong positions. The pro-Second Amendment attorneys argued that these bans could not withstand constitutional scrutiny because the firearms and magazines in question are already owned by millions of law-abiding Americans. Since they are in common use for lawful purposes like home defense, hunting, and sporting, they clearly fall under the protection of the Second Amendment's text. On the other side, the state of New Jersey argued that popularity does not automatically equal constitutional protection. They pointed to historical examples where weapons deemed dangerous and unusual, such as Bowie knives and machine guns, were restricted. Their strategy was to frame modern semi-automatic rifles and magazines as falling within that same category of dangerous weapons, despite their widespread ownership. The judges on the panel seemed divided. Some were openly concerned that applying a common use test might reduce the Second Amendment to a mere popularity contest, where rights expand or shrink depending on how many people own a particular firearm. Others questioned why states should be able to ban rifles that are among the most common in the country, widely owned for self-defense and other lawful uses. From the tone of the arguments, it appeared possible that the panel might strike down at least part of New Jersey's ban, particularly the prohibition on rifles like the AR-15. Still, it wasn't certain. There was a sense that the judges might try to keep their ruling narrow, perhaps only addressing AR-15s or the magazine ban, while leaving broader issues unresolved. They could also have remanded the case back to the lower court, with instructions to reconsider its decision more carefully in light of Bruen. At that stage, it seemed like a Pro-2A ruling was possible, though by no means guaranteed. However, before the three-judge panel could issue its decision, a major development occurred. The entire Third Circuit Court of Appeals, known as the banc court, stepped in and decided to take up the case themselves. On their own initiative, or sua sponte as it's called in legal terms, the full court issued an order announcing that it would rehear the case. The order set oral arguments for October 15, 2025. This meant the case would no longer be decided by just 3 judges, but by the full panel of active judges in the Third Circuit. The lineup of judges who will hear this case en banc is particularly important. The panel includes Chief Judge Michael Chagares, along with Judges Thomas Hardiman, Patty Schwartz, Cheryl Ann Krause, L. Felipe Restrepo, Stephanos Bibas, David Porter, Paul Mady, Peter Phipps, Ariana Freeman, Cindy Chung, Tamika Montgomery Reeves, and D. Brooks Smith. Here's the breakdown. There are 7 Republican-appointed judges and 6 Democrat-appointed judges. That's significant, because historically, judges appointed by Republican presidents have often leaned more favorably towards Second Amendment protections. Another key factor is Judge D. Brooks Smith, a senior judge who chose to participate in the en banc hearing. His participation tips the balance slightly more toward the Republican-appointed side, giving the Pro-2A side potentially stronger footing. The Third Circuit's recent history also adds weight to this development. For example, earlier this year, in January, the court ruled in favor of gun rights in a case involving 18 to 21-year-olds and Pennsylvania's concealed carry laws. Judge Smith was part of that decision, and he sided with the Pro-2A position. Additionally, in Range v. Garland, the en banc Third Circuit struck down a federal lifetime firearms prohibition against a man named Bruen Range, whose only offense was making a false statement on a food stamp application 2 decades ago. The court ruled that such a minor, nonviolent offense could not strip a person of their Second Amendment rights forever. Notably, Judge Ariana Freeman, who was appointed by President Biden, joined the majority in that decision. Even though she is a Democratic appointee, she ruled in favor of gun rights in that case, showing that the en banc court's decisions are not always strictly divided along partisan lines. With this backdrop, the split among the judges, the court's recent Pro-2A rulings, and the composition of the en banc panel, the upcoming October hearing could prove to be a turning point in the ongoing fight over firearm and magazine bans in New Jersey. This recent move by the Third Circuit en banc panel is not only unusual, but it is also incredibly significant. By taking this case out of the hands of the 3-judge panel and deciding to hear it themselves, the full en banc court has signaled that they view this issue as one of great importance. Oral arguments have already been scheduled for October 15th, which means we won't have to wait long before we begin to see how the judges approach these critical questions. During those arguments, one of the key things to watch will be how the judges respond to the lower court's reasoning. Specifically, will they take issue with the district court narrowing its focus almost exclusively to AR-15 rifles, while leaving unaddressed the broader category of firearms that New Jersey has banned, including certain shotguns and handguns? Another important point will be how they grapple with the fact that the lower court acknowledged magazines are considered arms under the Second Amendment, but still upheld the state's ban on those that hold more than 10 rounds. These contradictions are likely to be a central part of the en banc review. The significance of this case extends far beyond New Jersey. By moving forward at the en banc level, it places the issue one step closer to eventual review by the Supreme Court. That is critical, because the Supreme Court has already indicated, most notably through Justice Kavanaugh, that it expects to take up a rifle ban case in the near future. The court has also been watching cases like this one closely, especially after its landmark Bruen decision, which reshaped how lower courts are supposed to analyze Second Amendment cases. The magazine ban aspect of this case has already been granted, vacated, and remanded once by the Supreme Court after Bruen, and the fact that it is now back before the Third Circuit on banc adds even more weight. This could very well be one of the cases that sets the stage for the Supreme Court to finally rule on whether states can ban so-called assault weapons and standard capacity magazines altogether. This appeal has now become one of the most important challenges in the country against state-level bans on rifles and magazines. A ruling from the en banc Third Circuit could set the tone for how these bans are treated nationwide, and it may even be the case that ultimately forces the Supreme Court to deliver a final word on the issue. As we approach oral arguments on October 15th, we'll be watching closely to see how the judges frame their questions, what concerns they raise, and how the discussion unfolds. From there, we'll begin to get a clearer picture of where this is heading. I'll continue to keep you updated every step of the way as this case develops. And if you'd like to support the channel and stay informed, subscribing is one of the best ways to do that. Thank you again for your continued support. It means a lot.